Thank you. Honorable Minister has spoken. Now the motion is moved. Now I call upon the members whose names have been received for participation in the discussion. माननीय डॉक्टर अमर पटनायक जी.
Thank you. Thank you, Chairman, sir. Sir, on behalf of my party, the Biju Janata Dal, we support the amendment which has been brought in into the GST Act for exactly for the specific reasons that the Honorable Finance Minister has stated. That is number 2, to bring it in uniformity with the Tribunal Reforms Act 2021, and also to ensure that the number of cases that was going to the high courts because of the absence of this particular layer of adjudication would actually become operational, and therefore the number of cases would actually come down from the high courts and the Supreme Court, which already have a large number of cases. For the record, I think the Honorable Finance Minister has stated in several places that there are about 15,000 appeals which are pending at various levels before this particular amendment has been brought in, and this was 25% more than the last year. This is the latest figure which is available, around 15,000. Now, this particular amendment, when passed, would actually settle a number of these issues, and therefore it is very welcome. I compliment the government and the Finance Minister for it. Having said so, sir, there are 2 issues which I wanted to raise before the government by way of suggestion. Of course, one concern is that having the structure in place is one thing, but getting the vacancies filled up is another thing, and that is very important. In 2021, August 2021, the Honorable Supreme Court, the then Chief Justice, Justice Ramana, observed that there were 240 vacancies in these tribunals. And he expressed concern, and the advice to the government was to fill them up very quickly, because otherwise the entire process of the objective of forming these tribunals would not be achieved. Now, in 2022, to an unstarred question, number 1060, on 15/12/2022, the Minister of Law and Justice has given a position of vacancies in the tribunals. Now, unfortunately, Madam, these vacancies continue to be there at various levels. For example, in the Ministry of Corporate Affairs at the NCLT and the NCLAT level, the Ministry of Labour and Employment, in the Ministry of Finance at the DRT level. I don't want to get into each of the vacancies against each of these ministries, but these numbers, even after 1 year of the Honorable Supreme Court expressing concern, remains to be around 200 and 210. So I thought the next important thing that the government should be addressing is to fill up these vacancies by either revamping the existing machinery or process of selection of these members, judicial and technical members to these tribunals, or having a one-time measure to settle or to fill up these vacancies and then make the process roll on. Otherwise, the full benefit of this entire amendment would not be available to the people. The next point which I wanted to mention, sir, is the fact that the entire GST principle of one nation, one tax was brought in with the view to simplify the entire taxation law, have a common taxation law as far as indirect taxes are concerned in the country, and as Madam said, by subsuming a number of central and state taxes, that would improve the ease of doing business. This is one such step, and of course many states have already, and in the GST Council, have taken the next step of having a one-time amnesty scheme also for settlement of GST dispute in the line with Sabka Vishwas scheme of 2019. But there is one more step which probably I thought I would suggest by way of suggestion to the Honorable Finance Minister, that is the authority of advanced ruling under GST. Now, this particular architecture is welcome, but their entire view of looking at this thing is completely revenue-centric. Now, with the result that none budge from their position and there is no settlement. So each of the states have done this advanced authority for advanced ruling. Is there a need for the government and the GST Council to consider for a central authority for AAR, which could address the issues relating to place of supply and resolve the conflicting views of state-level advanced authority for rulings? This is where I think a big bottleneck is there. Honorable Finance Minister may like to address this. The second one is the recourse to alternate dispute resolution mechanisms, sir. I think this is a very potent method. And since we have brought in the mediation bill also now, it should be taken advantage of to reduce the number of appeals that is happening on the GST front, because that would improve the ecosystem of business in the country. The mediation bill the effort in this direction actually should come through the GST authorities themselves, because leaving it to the private authorities, actually the revenue-centric approach always ensures that the dispute is never settled. If the government itself uses the mediation bills, mediation act that we passed recently, some of the cases which are very clear and where the dispute can be easily settled, and settles these cases, it would give a big impetus to the private parties also to use this forum to settle many of these disputes. So overall, sir, I think the process, the entire architecture, there is nothing to quarrel about that. It is a welcome step. But we have to fill up these vacancies, and number two, probably look at other avenues of settlement of disputes, including alternate dispute redressal mechanisms. Thank you, sir.
धन्यवाद.